Shoot.
Great.
Thank you.
Go to the corner.
Yep.
Okay. Awesome.
Hello everyone. Thank you for coming. First, I'd like to gratefully acknowledge that we as an academic institution are on unceded territory of the Secwepemc people, and that we're personally and individually indebted to the Secwepemc people for the opportunity to work, study, and live here. To my mind, that means in material terms that we as legal scholars and practitioners ought to focus our attention to making the relationship between settler society and indigenous society more righteous and honorable. To my mind, this task is indeed both a constitutional and moral imperative. In the brief time that we have, I propose to speak about a very weighty topic, the relationship between settler society, of which Canada is exemplary, and First Nation society, which indigenous societies. Obviously, in the short time we have, it is not possible to thoroughly canvass and treat this topic. So with that said, I intend to limit my comments to drawing your attention to some conceptual tools which I believe could be of great practical use in advancing the historical and legal understanding of the processes of this relationship. What I want to convey to you is that economic anthropology has been recognized by the court as being of analytical utility to adjudicating cases concerning Aboriginal land claims. That while Karl Polanyi, you can see his model here, has been cited by the court, the conceptual framework of world systems theorist Kojin Karatani is of superior analytic utility to Polanyi's in the situation of analyzing the relationship between settler society and First Nation societies. So you can see here the way he spells it out, and this is from Locke's Club, where they were trying to ascertain what the nature of the society was. They cited Polanyi to the extent that he's offered these as essential modes of exchange. But Polanyi's model is different. What it's meant to do is specify different types of states with respect to one another. So you've got Nordic model social democracy, American capitalism, and command economy such as the former Soviet Union. That's what his aim was in the model that he was using. In Lax Kolam's Indian Band 2008, the British Columbia Supreme Court draws upon Dr. Stephen Langdon, as an economic anthropologist and professor at the University of Alaska, whose particular expertise is in fishing economies with groups on the northwest coast. Justice Santinov notes that Dr. Langdon is qualified as an expert in, quote, cultural and economic anthropology, ethnohistory, archaeology, and maritime societies on the northwest coast. Dr. Langdon draws the court's attention to the work of Karl Polanyi, who they note is one of the first economic historians to explore the distinctions in human systems of exchange. The court found that, quote, Polanyi's theory was that each society had one of the above as the dominant feature, which could be effectively understood as a distinct set of practices or activities divorced from the societal and cultural context. And so I've got a whole bunch of world systems texts on the bottom here and economic anthropological texts on the top here. The point that I'm trying to illustrate to you, I'll just say, there are many other foundational figures that one might look to if one were to draw from the disparate threads of world systems theories, anthropology, political economy, sociology, and the like. One could and ought to draw from the works of Ferdinand Braudel, Emmanuel Wallerstein, Marcel Mauss, Claude Lévi-Strauss, Marx, Weber, Freud. Marxists and some liberal political economists, as you may be aware, have understood the developments of societies from the perspectives of modes of production. In other words, society is determined by the way it structures and organizes the production of necessary goods for the social formation, from hunter-gatherers to hydraulic despotism to industrialism. This is an important way to understand society. An aspect of Professor Jones' theory of tort, for example, is understanding the development of tort law is at least in part a function of changing modes of production. There are, however, important and structurally determining elements of a society which a narrow focus on modes of production necessarily misses. And in the 20th century, these analyses became the stuff of cultural critique, the Frankfurt School, psychoanalysis, and structural anthropology. So, the advantage of Kojin Karatani's modes of exchange, articulated in his text, Structural World History from Modes of Production to Modes of Exchange, is that he has succeeded in integrating all of these disciplines and others into a single coherent social and political analytic, which he calls modes of exchange. While preserving the analytical insights of modes of production analysis, Karatani's modes of exchange analysis deftly integrates the insights of these latter analytics. The advantage of Karatani's frameworks over Polanyi's is that Polanyi's framework is oriented towards specifying the differences between strictly capitalist economies, social democratic economies, and command economies, like that of the former Soviet Union. It is not at heart a framework for speaking to the difference between state society, capitalist society, and indigenous societies, whereas Karatani's is. What is important to note is that economic anthropology is not developmental or evolutionary. What this means is that economic anthropology does not begin from the standpoint that certain societies are fated to become other than what they are. Gilles Deleuze and Felix Guattari, for example, write that indigenous societies do not precede states in a developmental fashion, but rather coexist with them in a complex network in perpetual interaction. The non-developmental orientation of economic expertise as a discipline owes much to the work of Pierre Clastres, which is why I put a picture of his text here. Karatani writes that the four different modes of exchange coexist in all social formations and differ only on which mode is dominant. For example, in capitalist society, mode of exchange C is dominant. I'm going to run through the modes very quickly so I can actually speak about honor of the crown, hopefully. Societies in which mode of exchange A is dominant have classically been called clan societies or kinship societies. Karatani argues that these societies are oriented by the relationships of gift, counter-gift, and arise where, quote, a higher order community is established through the principle of reciprocity, end quote. Karatani writes that this kind of league is not always stable and harbors much internal chaos, meaning that it must from time to time be reconfirmed through additional reciprocal acts of gift-giving. The unity of the community is established through reciprocity, is segmentary in nature, and it is not a structure capable of governing from above, i.e. a state. And this is a Kawak Udal potluck, and the potluck or feast is very important in clan societies and kinship societies. So, mode of exchange B. I got the pyramids, the Aegean city-states, Hobbes's Leviathan, and Fort Victoria there. I'll kind of run through. Mode of exchange B is what's commonly understood as state society. Karatani writes that mode of exchange B, quote, consists of ruling and protection, and that as a consequence of the emergence of the state, quote, a non-reciprocal mode of exchange becomes dominant. Of the ancient Egyptian state, Karatani writes, for example, with the establishment of the state, the gods acquired transcendental status, which implied at the same time an increase in the power of the chief priest, which becomes a bureaucratic core. Karatani writes that with the emergence of the state, mode of exchange B suppresses the principle of reciprocity inherent to societies whose dominant mode of exchange is mode of exchange A, with equality, both in terms of equality and vendetta, and subordinates them to a univocal authority. Mode of exchange B is dominant in two types of societies, despotisms and republics, and indeed the great bulk of political science is articulating the difference between a republic and a despotism. Despotism functions on command, republics function on consent. In a despotism, the ruler rules by fear and control. In a republic, the ruler rules by contract. This is why mode of exchange C, commodity exchange, develops in republics and not despotisms, because the rational and contractual elements of mode of exchange C, commodity exchange, are formally, if not substantively, antithetical to rule by irrational force. Mode of exchange C. Mode of exchange C is what we commonly understand as capitalistic society. In that society in which commodity exchange is dominant and arises where exchange is neither constrained by the obligations inherent in gift-giving, as in mode of exchange A, nor imposed through violence, as in the pillaging of mode of exchange B. Karatani writes that, quote, mode of exchange C, commodity exchange, brings about relations of class, which are of a different nature from the relations of status that are generated by mode of exchange B, even though these two are often connected, end quote. In other words, while, quote, the plunder redistribution model of exchange lives on at the core of the modern state, at the same time, quote, mode of exchange C produces a kind of class domination different from that which is grounded in fear, end quote. The point to understand is that mode of exchange C is irretrievably hybrid and inextricable from mode of exchange B. The economic class which emerges in the 17th century wields the power of commodity exchange, mode of exchange C, in virtue of their separation from and attenuation of mode of exchange B, the state. In other words, it is in virtue of the limits or controls to which the state is subject. Mode of exchange C is thus a partial mode. And then mode of exchange C, you don't really need to know all of this for this talk, but it's worth knowing that it's a four-part model, and mode of exchange D is an associative mode. So it subsists in basically social movements. One could think of the agitation of French peasants prior to the Revolutionary War. One could think of the Winnipeg General Strike. The two examples that I've given here are May 68 at the Sorbonne and Burnaby Mountain in 2014. It is a mode which is oriented around collective action. So mode of exchange D is an associative mode. Exchange is associative and unmediated. Karatani writes that mode of exchange D transcends the other three in that it, quote, consists not only of the rejection of the state that was generated through mode of exchange B, but also a transcending of the class divisions in mode of exchange C, and thus the return of mode of exchange A in a higher dimension. Karatani writes, quote, what Kant, this is Immanuel Kant, so he's writing late 1700s, and so what Kant discovered as the universal moral law was precisely the mutuality, reciprocality of freedom, in short, mode of exchange D. Thus, rather than being a mode of exchange which is dominant in any given contemporary society, Karatani writes that Kant's notion of world republic, the kingdom of ends, is, quote, a regulative idea. I used these examples here. But again, it's kind of a normative point, less relevant for this talk. So, now I can jump into the honor of the crown here. So the honor of the crown is the standard of dealing owed to indigenous societies. And the honor of the crown is implicated in all dealings with indigenous peoples. In St. Catherine's Milling and Lumber Co. versus Regina, 1888, essentially our legal systems riposte to the U.S.'s findings in Johnson versus McIntosh, 1823. The Judicial Committee of the Privy Council found that Aboriginal title stems from, quote, the royal proclamation in favor of all Indian tribes then living under the sovereignty and protection of the British Crown, end quote. In Calder versus Attorney General, BC, 1973, the Supreme Court found that its origins are rather in the fact that, quote, when settlers came, the Indians were there, organized into societies and occupying the land as their forefathers had done for centuries. In other words, the fact of prior occupation by indigenous societies, societies in which mode of exchange A is dominant. The honor of the crown is rooted in the interrelation of these twin origins, that is, the assertion of crown sovereignty with an acknowledgement of Aboriginal interest and the fact of pre-existing indigenous societies. It is a particularly auspicious day today to be giving a talk like this because we can see very clearly in the actions of the RCMP on Wet'suwet'en territory the way that society in which mode of exchange B is dominant, working at the behest of society in which mode of exchange C is dominant, forcibly dispossesses societies in which mode of exchange A is dominant. Now, I want to talk about two rulings, basically. One is the Coldwater case ruling that came out this week, and the other is the Coastal GasLink pipeline injunction ruling. The Coldwater Indian Band ruling concerns the Trans Mountain pipeline as opposed to the situation in Wet'suwet'en territory, which concerns the Coastal GasLink pipeline. But the structure in terms of modes of exchange is identical and describes the relations between the actors. In Coldwater Indian Band, the court found that the Governor and Council had complied with the duty to consult. Perhaps as a consequence of the recent Vavilov ruling on administrative law, the Federal Court of Appeal found that consultation efforts of the Governor and Council to have been reasonable, quote. The court takes pains to emphasize, citing Gixala Nation, that there may be omissions, misunderstandings, accidents, and mistakes, and, quote, difficult judgment calls on which reasonable minds will differ, end quote. At para 54 of the Coldwater ruling, the court states, too strict a standard of perfection, reasonableness, or meaningfulness in assessing whether the duty to consult has been adequately met would create a de facto veto right, end quote. I don't think that the ruling in Coldwater would stand up to Supreme Court scrutiny for this reason. With respect, this reasoning is totally at odds with Supreme Court construction of the requirements of the honor of the crown. The honor of the crown requires honorable and fair dealings, not merely reasonableness. In the Queen versus George, 1966, Justice Cartwright writes that the arrangements which concern indigenous peoples should be construed, quote, in such a manner that the honor of the sovereign may be upheld and Parliament not made subject to the reproach of having taken away by unilateral action and without consideration the right solemnly assured to the Indians and their posterity, end quote. Justice Dixon found in Nowajik versus the Queen in 1983, treaties and statutes relating to Indians should be liberally construed and doubtful expressions resolved in favor of the Indians, end quote. In Sparrow, 1990, Chief Justice Lemaire and Chief Justice LaForest found that the court, quote, must hold the Crown to a high standard of honorable dealing with respect to Aboriginal peoples of Canada. Justice Cartwright found in the Queen versus George that if the alternative is a narrow construction of a grant or an expansive construction, the court is to opt for the expansive construction because, quote, it is not the sovereign's intent to make a void grant, end quote. In Haida, the court found that the honor of the Crown is, quote, not a mere incantation, but rather a core precept which finds its application in concrete practices, which must be understood generously in order to reflect the underlying realities from which it stems. The court in Mitchell versus MNR 2001 found that the Crown is obliged to deal with Indigenous peoples, quote, fairly and honorably and to protect them from exploitation. Of this, one could say that the court has established a duty on the part of the state, mode of exchange B, to protect First Nation societies whose dominant mode of exchange is mode of exchange A, from exploitation by society in which mode of exchange C is dominant, commodity exchange. Legal theorist Mariana Verde describes rooting relations between settler society and First Nation society in the honor of the Crown as an effort in, quote, refurbishing the Crown for a multicultural age, end quote. She argues that pre-modern notions of the Crown as inherently honorable reflect, quote, paternalist, pre-modern, crypto-Christian logics, end quote. With that said, in Manitoba Métis, the court stresses that the honor of the Crown is not a paternalistic concept, but rather a recognition of their strength. The court, citing Brian Slattery, writes that the agreements entered into by the Crown stemmed from, quote, the necessity of persuading Native peoples at a time where they still had considerable military capacities that their rights would be better protected by reliance on the Crown than by self-help, end quote. In that sense, it is a recognition of that the existence of Canada, mode of exchange B in this instance, historically depended on the military strength of First Nations, or societies in which mode of exchange A is dominant. On the one hand, Valverde notes, quote, Canadians are engaged in discussions about the remedial justice or about special provisions for Aboriginal offenders or for Aboriginal spaces, but on the other, quote, few Canadians are asking more fundamental questions about whether acknowledging Canada's colonial rule over Aboriginal peoples necessitates putting in question our white Canadian knowledge of ourselves, our institutions, and our rules. And I had a whole bunch of stuff on the Coastal GasLink pipeline ruling, but in the interest of time, I'll just give you the punchline, which is that in that ruling, so we have the situation unfolding with the RCMP acting, you know, one might say, somewhat dishonorably in Wet'suwet'en territory. If you go, and I think that that's dishonorable and one can critique the executive, but what I want to focus on is potentially dishonorable reasoning in our juridical kind of environment. If you look at that injunction ruling, there's a whole bunch of problems with it. But the main one that I want to point out is that in denying independent weight to the evidentiary, the evidence put forward by the Wet'suwet'en in the form of affidavits from Dr. Anatolia Mills, Justice Marguerite Church of the BC Supreme Court, she cites the trial judge in Delgamuukw and says the trial judge in Delgamuukw didn't put any evidentiary weight on this evidence, so neither will I. But the point is that in that case, in Delgamuukw, as it was coming up the court, the trial judge's how the trial judge dealt with the evidence of First Nation societies was the issue. In 1993, Justice of Appeals Lambert found that the trial judge had, quote, applied incorrect legal tests, and that while the appellate courts generally don't interfere with the findings of fact by the trier of fact, they are at the same time not obliged to stand idly by while there is, quote, a miscarriage of justice. Chief Justice Lemaire and Justice LaForest found in Delgamuukw that the trial judge had made serious errors of law on precisely this point, and as a consequence of this, quote, the trial judge's conclusions were wrong. And this is, so in order to facilitate the RCMP actions that are currently ongoing, the injunction issuing judge is citing the trial judge who had been found to be wrong, to have applied incorrect legal tests, to have reasoned incorrectly with respect to this. And I think that that's especially dubious. So I'm going to jump to the end here just so that we can, in the interest of time. Now you may say, well, that's all well and good, but what have world systems theorist Kojin Karatani and his modes of exchange schema to do with all of this? Well, when the court acknowledged in Vanderpeet that there had been a, quote, superimposition of laws, what they're saying is in effect that our circumstances are circumstances in which there has been a superimposition of society in which modes of exchange B and C are variously dominant, state and capitalist society over society whose dominant mode of exchange is mode of exchange A, reciprocal exchange. It is just as true to say colonizer and colonized, settler society and indigenous society, industrial society and kinship society, but these appellations say nothing in particular about the way that that comprises the differences between them. Whereas saying society in which the dominant mode of exchange is reciprocal exchange and society in which the dominant mode of exchange is ruling for protection or commodity exchange does. I want to leave you with the often quoted passage from R.V. Taylor and Williams in 1981 that, quote, although it is not possible to remedy all that we now perceive as past wrongs in view of the passage of time, nevertheless it is essential and in keeping with the established and accepted principles that courts not create by a remote, isolated view of past events, new grievances, end quote. It is my hope that an expanded understanding of not only the anthropological past of settler society and indigenous society, but the anthropological present of settler societies and indigenous societies would contribute to this work. Thank you very much. Go.
It's not really about the topic, but I was wondering, in the last case, I got the insinuation that the judges kind of mischaracterized the anthropological text that they were quoting. Do you think that the judge, or if they were to do something similar, do they have an obligation to stick to what the author was originally trying to say, or can they morph whatever they're saying to suit their needs?
Well, what's interesting in Laxalams is what I'm quoting from is actually I think it's the BC Court of Appeal, and the findings of fact by the time it reached the Supreme Court already worked out. And what I'm acutely aware that anthropological evidence was being marshaled to prove something that is kind of malign. Is the court wanted to say, well, this is just a kinship society, they don't do commercial exchange, it's not part of their society, and so the anthropologist, especially Dr. Stephen Landon, he was having to say, yes, the dominant kind of way that the society orients itself is reciprocity, but there is evidence that they did other than that they were long-distance traders, that they did move about and keep substantive surpluses for the purposes of commercial exchange. So in that instance, the court just wanted to hear anthropological evidence so as to deny the First Nations society the right to commercially trade. But what Dr. Stephen Langdon and economic anthropology generally wants to assert is that Indigenous societies are more complicated than that. I don't think that you should have to establish that your mode of exchange was one way to deal with the present in a commercial way, because the fact of the superimposition of Canada has changed the basic way that we support ourselves and create sustenance for ourselves. So saying, oh, well, you're not allowed to commercially trade now because you didn't back then, that's kind of offensive to the anthropological kind of mind. That's what the court's interest is in it, and I think that ought to change.